I want to talk a little bit about the rights in the European Convention. Let's start with a general definition of human rights, or a human rights regime. I'm referring to a regime here because clearly we have a convention and a court. A regime of human rights is a consistent understanding of or provides a consistent understanding of the way in which rights are to act as limits upon the sovereign power of the state. Now, I want to really think more about how we can understand the convention rights themselves. I'm going to use certain categories to group together the rights in the convention. Now, these categories are not hard-edged, they're not hard and fast, they're just categories that I think allow us to appreciate the fundamental form of the convention and the way in which these rights fit together. And I suppose I'm doing this in part because we haven't got time to look at in detail how each of these rights work themselves out in terms of the case law of the European Court of Human Rights, or indeed in terms of the development of human rights principles in the law of the United Kingdom. So it struck me what I could at least do is talk about how we can group together the rights within the Convention to understand how the Convention works. And I want to look in detail perhaps at the structure of an exemplary right, again with the intention of understanding how human rights works. So the first category I'm going to use to talk about rights, I'm going to give the title integrity rights to. Now, hopefully the reason for that will become clear as I continue talking. I want to include in this first group of integrity rights Articles 2 and 3 of the Convention. Article 2 protects the right to life, and Article 3 is the prohibition on torture and inhuman or degrading treatment. Now, these rights, therefore, are aimed at the protection of a citizen's bodily integrity. The rights to bodily integrity, Articles 2 and 3, thus prohibit certain forms of punishment, torture, and also place limitations on the taking of life. Now, the other group that I could talk about in relation to this idea of integrity takes us to, I think, related but distinct concerns. Now, I still want to use the word integrity, but I want to use it in a different sense. If I refer briefly to Article 5, we could see that Article 5 relates to the right to liberty and security. Now, that might in some ways allow us to group it under that first category, in that it's to do with the integrity of a citizen's right to liberty, to not be falsely arrested, for instance. Now, that might link it to that first category, but it also, I think, links it with this second grouping of rights that I want to just also refer to as integrity rights. But I think that I'm using the word integrity in a slightly different way here. I'm using it in a different way because I think what I'm referring to is the way in which rights protect due process and the integrity of legal proceedings themselves. So not so much Articles 2 and 3, for instance, that protect the right to life or prohibit torture in inhuman or degrading treatment. Obviously that's relating to prohibitions on what a state can do to your body or to the body of a citizen. This other grouping of rights, that I'm going to use the word integrity to describe, relate to the way in which human rights themselves protect due process and the very structure of human rights law. Now, into this grouping of rights, I would like to include and describe the following rights. I'd like to include Article 6, which is the right to a fair trial. Now, the right to the fair trial, or a due process right, is clearly a right that protects the way in which the court operates, to ensure that a court operates in a transparent and accountable fashion. And it's a right that ensures that certain the rights of the defence or what have you are guaranteed. In other words, these rights protect the integrity of court procedures themselves. Article 7, no punishment without law, clearly also relates to the integrity of legal procedures, particularly criminal procedures. We cannot punish somebody without having clearly defined legal procedures. It seems to me legitimate to describe this kind of right as an integrity right. It relates to the integrity of court processes, rather like a due process right, rather like Article 6, in other words. Two other rights that I also want to include in this category of integrity rights are Article 17 and Article 18. Article 17 is a prohibition on the abuse of rights, and Article 18 is a limitation on the restrictions on rights. Both these two articles, I think, illustrate quite clearly how human rights themselves protect the integrity of legal procedures and indeed protect the very idea of human rights. However, the idea of integrity rights, whether integrity of procedure or integrity of the bodies of citizens, these are clearly important elements of a human rights regime, but I want to turn our attention from integrity rights to the so-called classical civil liberties. Now, the classical civil liberties include Article 10, freedom of expression, and Article 11, the freedom to assemble and to associate. These, I think, are exemplary of substantive civil liberties, the kind of civil liberties that the common law, for one, has always identified itself with and stood for. They go beyond the integrity of procedures and relate to specific civil liberties which characterise a life in a democracy. The next group I just want to briefly overview is perhaps the most problematic in comparison with other international catalogues of rights, such as, for instance, the International Covenant on Economic, Social and Cultural Rights. The Convention offers rather limited protection in terms of this form of social right. Article 4, for example, the prohibition on slavery and forced labour, is perhaps as far as the European Convention goes. In other words, in comparison with the International Covenant, what we don't find are explicit statements of, say, the right to education or the right to healthcare, these social and economic rights. What we find is an important but much more limited right, the prohibition on slavery. The next group of rights that I want to look at, I'm going to define in the following terms. This group of rights define minimal forms of civil society and basic forms of social plurality. As far as that first category is concerned there, I want to talk a little bit about Article 8, the right to respect for private and family life, and Article 12, the right to marry. These are limited forms of, if you like, civil association, in other words, the right to marry. It's not a massive statement of the kind of rights that we can expect in a society, but it is an important personal right. Likewise, the protection of privacy, Article 8. I referred a moment ago to basic forms of social plurality, and I want to link this to Article 9, which guarantees the freedom of thought, conscience and religion, and Article 14, which is the prohibition on discrimination. Now, in dividing rights into these categories, I just really wanted to show that the Convention provides a coherent statement of both basic political and legal principles that I think, if I had time to argue, I could show are coherent with democracy and the rule of law. I said at the beginning, and I think I just want to stress again, that these rights are not, if you like, hard-edged. I mean, you could come up with different ways of classifying or categorising the rights under the Convention. But the point of my analysis was, as I say, to try and draw out the coherent way in which the Convention, or in which Convention rights, allow us to think about basic legal and political principles. What I want to do now is look at the basic structure of a right. And I'm going to, again through really pressures of time, just look at Article 10. In other words, I'm concerned with the wording of this article, how we can understand the scope of Article 10. In other words, the freedom of expression, one of the classic civil liberties. So let's first of all look at the wording of the Convention right. It's got two paragraphs, and I'm going to read these two paragraphs to you, and then I'm going to analyse the rights that are so contained, or indeed the limitation of these rights. So, paragraph 1. Everyone has the right to freedom of expression. This right shall include freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. The article shall not prevent states from requiring the licensing of broadcasting, television or cinema enterprises. Paragraph 2. The exercise of these freedoms, since it carries with it duties and responsibilities, may be subject to such formalities, conditions, restrictions or penalties as are prescribed by law and are necessary in a democratic society in the interests of national security, territorial integrity, or public safety, for the prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation or rights of others, for preventing the disclosure of information received in confidence, or for maintaining the authority and impartiality of the judiciary. Okay, let's think a little bit about those two paragraphs. Go back to the first paragraph. Statement of the right. Everybody has the right to freedom of expression. We then have the amplification of this idea, i.e. what the right includes. This right shall include the freedom to hold opinions and to receive and impart information and ideas without interference by public authority and regardless of frontiers. Here's the positive statement of the right. That's what it allows us to do. But then note the following, the third sentence in the first paragraph. This article shall not prevent states from requiring the licensing of broadcasting, television or cinema enterprises. In other words, the right to freedom of expression is entirely coherent with the state's power to require the licensing of certain forms of disseminating information or indeed entertainment. Paragraph 2 is very interesting, isn't it? What we have in paragraph 1 is primarily the positive statement of the right. What we then have in paragraph 2 is a statement of the limitation of that right. The exercise of these freedoms, since it carries with it duties and responsibilities, may be subject to such formalities, conditions, restrictions or penalties as are prescribed by law and are necessary in a democratic society. Let's just hold the clause there. These freedoms, the right to freedom of expression, carry with them duties and responsibilities. Because of that, they may be subject to various limitations, which are outlined as formalities, conditions, and restrictions or penalties. But note, these restrictions on the right are themselves limited by law and the extent to which they are necessary in a democratic society. So any limitation on a right has to be checked against that statement. Now, if we bring these various ideas together, it would seem that a state can limit a right, but any limit that a state places on a right itself has to be justified, and has to be justified from the perspective of, well, democracy, but not just democracy. Other issues are brought into focus here. Limits on rights are also possible in the interests of national security, territorial integrity, or public safety, etc., etc. In other words, one of the interesting things in the law of human rights is the extent to which A, we have the right, and B, the extent to which that right can be limited. Now, there are different ways of looking at this, but one of the interesting ways is saying that a right correlates with duties and responsibilities. In order for that right to be, if you like, exercised in a responsible way, we have to understand the functioning of that right within this democratic context, where limitations on the right, in this case the right to freedom of expression, may be legitimate.